The idea today in terms of talking about cannabis in the workplace is really having a focus on policies, a focus on your workplace policies. I'm going to stay fairly high level today. You know, I very much appreciate the time of day and how much time and effort everyone's put into to get to this point. So Chad, what I'll ask of you is if we get to 3:40 and I'm still talking, give me a wave. But at the same time, while I'm going to stay fairly high level, you know, we're going to give you this presentation afterwards. It is a lot of information. Please feel free to, you know, give me a call, send me an email or whatever. I'll talk to you about cannabis and workplace policies as much as you like. So certainly, you know, the objective for this presentation is to give a sense to employers about the reasons to have solid workplace policies, the impact of policy of cannabis on those policies, and to talk about some elements from a human rights perspective in terms of accommodation. Okay, I'm going to skip over the first slide and just let you know, of course, we know that the Cannabis Act, this is coming into force in July. The Cannabis Act is going to allow adults to legally possess, grow, and purchase limited amounts of cannabis for personal recreational use. Here in Saskatchewan, the provincial government recently introduced its proposed cannabis framework and has introduced legislation. Generally speaking, you know, the main points are up there. The minimum age to purchase, possess, or consume cannabis will be 19, except with medical authorization. There's going to be zero tolerance for drug-impaired drivers, and consumption in public spaces, schools, and daycares is going to be prohibited. This legislation, you know, hasn't been passed yet, but this provides us with a pretty good sense of what that legislation, you know, once it is in its final pass stage, is going to include. Cannabis itself contains hundreds of chemical substances. The two most commonly known are THC and CBD. THC is responsible for the way that your brain and your body responds to cannabis, and it produces the sort of generally known high. CBD is not psychoactive, and it's the one that's often studied for its potential therapeutic uses. In terms of the forms of cannabis, of course, it can be taken a number of different ways: smoking, drinking or eating, vaping, or through baked goods. The effects of cannabis, the ones that result from THC, can remain in the body for a long time after use. And as we're going to talk about, and as you may be aware, THC can remain in the body for a long time after use. So it can come up in testing, blood or urine, long after the effects of the impairment have worn off. Generally speaking, from a recreational use perspective, what cannabis causes is a number of different types of impairment in motor skills and concentration, attention and memory, and it can cause dizziness or disorientation as well. From a workplace safety perspective, of course, what this means is that it's going to impair one's ability to drive safely or to operate equipment. It may make it harder to learn and remember things, and it can affect moods and feelings as well. The level of impairment that results from cannabis can depend on a number of different factors. I've mentioned a few of them here. Certainly from the perspective of the method of consumption, smoking cannabis results in a very rapid onset of effects, essentially within a few minutes, with a peak effect after about 30 minutes and a duration of between 2 and 4 hours, whereas ingesting cannabis, such as through a baked good, has a slower onset of effect with more progressive and prolonged effects, but with less euphoria. From a therapeutic use perspective, cannabis is prescribed to treat a number of different ailments. We have the word prescribed in quotation marks because it's not actually an approved drug. It hasn't undergone the rigorous study or testing that's required. Individuals may obtain medical authorization, which is essentially the equivalent to receiving a prescription, for therapeutic use in cannabis. Is there a practical difference for employers, you know, for a worksite safety perspective? Perhaps not, but there is a distinction in terms of how they are treated, and that's why we make the distinction in the presentation. Medical cannabis, similar to recreational cannabis, can be administered using a variety of methods: liquid tinctures, vaporizing or smoking, eating edibles, taking capsules, etc. So why the focus on cannabis? And you know, really, what's the point of having this conversation? Many employers, especially large employers, already have a set of workplace policies, including occupational health and safety policies. Lots of people have asked, you know, if we have in our policy the general expectation for employees to show up sober, is that enough? It's a good question. Essentially, there's two primary reasons that we're focusing. One is occupational health and safety, we'll review that, and the second is accommodation in the workplace, sort of from the human rights perspective. On the human rights side, there's two sort of subset issues. The first are the obligations of an employer when someone has authorization to use medicinal marijuana, what happens in that situation. And the second is, what are an employer's obligations when somebody develops a dependency to cannabis? Because dependency has been found to be a disability, which brings it under the Human Rights Code. So the reason it's important to have updated, thorough policies when it comes to cannabis in the workplace is because of the significant legal issues for failing to do so. So I've listed these legal issues here. We're going to go through them quickly. But think about a workplace incident that occurs because of an impaired employee. This may result in time loss, damage to equipment, a civil claim for damages in some circumstances, or charges under occupational health and safety legislation. Where an employer fails to properly or appropriately accommodate an employee with a disability, that employer may be liable for damages via a grievance or a human rights complaint. In terms of worker privacy, breaching a worker's privacy can result in a grievance in unionized workplaces or a complaint to the Information and Privacy Officer with a resulting investigation. And really one of the underlying themes in terms of the presentation and the information I'm sharing is, the outcomes to not having these well-developed policies are not only the potential of facing a human rights complaint, but all of the necessary time and effort that an employer has to put into responding to that. I sort of liken it to, the ounce of prevention is worth much more than having to actually deal with these types of issues because you didn't take the proper steps. So from a health and safety perspective, the duties imposed on an employer, regardless of the type or manner of worksite, include the obligation to ensure that the employer's workers are trained in all matters that are necessary to protect their health, safety, and welfare. There's corresponding duties that are placed on supervisors, contractors, prime contractors, owners, and suppliers. Employees have specific obligations as well. We'll talk about those, but generally speaking, everybody has a duty to ensure the safety of a worksite. So what hasn't changed? Certainly what hasn't changed is the basic obligation, the basic expectation that employees are not permitted to be impaired at work or to pose a safety risk. And that's regardless of whether they have a prescription for medical marijuana and regardless of whether cannabis is legal. So I want to talk for just a minute about due diligence, and this is the third time today that this term has come up. Both Derek and Ahmed mentioned it, and I was reflecting a little bit. I think really the non-legal definition of due diligence is do your homework, and it applies equally in a workplace perspective. From an occupational health and safety perspective, due diligence is the level of judgment, care, prudence, determination, and activity that a person would reasonably expect to do under particular circumstances. And here, reasonably practical is taking those precautions that are not only possible, but that are suitable or rational given the particular situation. What constitutes due diligence is going to vary and must be considered on a case-by-case basis. So what's appropriate for an office or a retail setting may not be appropriate for a manufacturing or a construction site. Essentially, due diligence is what you must show as an employer to demonstrate that you've met your obligations under the Saskatchewan Employment Act to provide a safe work site. Due diligence is going to start with your occupational health and safety policies, practices, and procedures. And I've listed 4 here, workplace safety audits, identifying hazardous practices, providing appropriate training, and implementing those changes that are necessary to correct hazardous practices. Due diligence is a legal defense, and under the occupational health and safety perspective, it's a legal defense, and it asks 3 questions. The first is foreseeability. Could a reasonable person foresee that something could go wrong? The second question is preventability. Is there an opportunity to prevent an injury or an incident? And the third question is control. Who has the ability or the responsibility to prevent an injury or incident from occurring? And most often, this is going to be the employer. So in an office setting, due diligence may be checking for trip hazards, such as boxes that are piled up, and implementing a protocol as to where those boxes should properly be stored. In a retail or restaurant setting, due diligence may include having a policy that mandates two employees will be on duty at night for safety reasons. And for a construction company, due diligence may include daily tailgate meetings to review safety considerations for the job that day, and having a hazard assessment process in place to continuously check for and correct any potential hazards. In every situation, due diligence is going to include providing information to employees. So in terms of drafting or updating your occupational health and safety practices or procedures, what I've got here is a number of considerations that you should take into account. I'm not going to go through each of them, but certainly one of the most important ones is the final one, which is that they should be available and effectively communicated. I think that because of the cannabis discussion, because of legalization, a lot of employers are looking at their policies, they're updating them, which is a really great, it's best practices, but don't let it end there. There has to be a plan in place to communicate that to your employees, to have a training program in place so that they understand, and I'm going to come back to this, so that they understand the expectations that you're placing on them as an employer. Essentially, don't just update or draft your policies and then stick them in a binder. So due diligence is the defense. It is what must be proven to successfully defend against charges under the occupational health and safety legislation, because these are the penalties for failure. And what I've identified here are the financial penalties for failure, but of course, there's much more significant ones than these, and that's the potential serious injury or the loss of life of a worker, which nobody ever wants to see. It's all of the resulting downtime that comes from having to investigate and respond to a serious incident or a fatality. Nobody wants that. But in the event that you find yourself as an employer in that situation, you have to be able to prove due diligence to show that you took all reasonably practical steps. Otherwise, you're facing fines of up to $1.5 million. So we've discussed the legal scheme and the requirements placed on an employer to maintain a safe work site. What does that have to do with cannabis? Well, cannabis is an intoxicant. The sky may not fall with respect to legalization of recreational cannabis. I'm not expecting that on July 2nd or once the retail shops are set up, early September, that all of your employees are going to come to work high as a kite, or that you're going to have a problem dealing with people who on their breaks go out and sit in their cars and smoke a cannabis cigarette. I don't think that's what's going to happen. But what I do think is going to happen is there's going to be an ongoing conversation and perhaps a shift in terms of acceptability of the use of recreational marijuana. Similar to alcohol, people may reasonably find it socially acceptable to partake in cannabis use recreationally. The example I've been giving is, you have a company ball team who plays games every Saturday afternoon in the summertime. It's socially acceptable for that company ball team to go for a beer after the game. Is it conceivable that at some point in time it may be socially acceptable for that ball team to go to a place and partake in cannabis use? I read just over lunch, I was looking, CBC has an article up, I haven't looked at the details, but the Second Cup coffee shop is pairing with a cannabis distributor, and what it looks like they're going to try and do is essentially set up pot shops that people can go into and partake in cannabis use. So I don't have any details other than this, but you can see where people are going with this, and you can see even in the course of the next 1 to 3 years what other options may be out there. I think that we really are going to see a shift in terms of people seeing or thinking what's acceptable and perhaps talking about that a little bit more. So why are we having the conversation? The short answer is that your employees need to know what's expected of them. We've reviewed why it's important for employers to establish a due diligence defense to avoid the regulatory penalties. You need to have these policies in place. But consider it also from the perspective of managing your employees. If you have an employee who shows up to work impaired, you want to be able to discipline them up to the point of termination in certain circumstances. You need to clearly establish expectations and outcomes for failing to meet those expectations. Really, the best way to do that is through your workplace policies, which apply equally to all of your employees. And the outlier or the obvious situations, those are the easy ones to deal with. You think about cannabis use, recreational cannabis use, everybody thinks about the guy who's operating a bulldozer while smoking a joint at the same time, right? Like you go to the far ends. Those are the easy ones. What will be much more difficult to deal with are those situations where you catch a whiff of perhaps some stale cannabis smoke off an employee's jacket and you wonder when it was that he consumed that. Or you have a supervisor who overhears two employees talking in the lunchroom and one says to the other that last night while he was watching a movie, he enjoyed a large cannabis joint. If you have a suspicion that you have an employee who's impaired, what would you do with that situation? Because broadly speaking, employers are not able to dictate what their employees do during their off time. And that's why when we talk about zero tolerance policies, they can be difficult to implement. Not a zero tolerance policy for coming to work sober, but a zero tolerance policy in terms of not partaking in cannabis use at all. What an employee does on their off time in terms of recreational cannabis is perfectly legal. So what's the balance between the outlier situations and trying to implement a policy that says, our employees cannot use cannabis full stop? So in terms of the second legal issue, let's look at the obligations that are placed on employers under the Saskatchewan Human Rights Code. Generally speaking, we know cannabis causes impairment. What do you do when an employee provides a doctor's note authorizing the use of medicinal marijuana? And like alcohol, people may develop a dependency on cannabis. It's expected that, similar to other drugs and intoxicants, such dependency will be treated as a disability. Employers have an obligation to accommodate workers with disabilities, which includes both the use of medicinal marijuana because of an underlying illness or chronic disability, or accommodating the disability of substance dependency. And again, you're looking not only at the time and expense that's involved with responding to a human rights complaint or defending against that, but under the code, the courts have very broad remedial powers and can order both reinstatement of employment if somebody's been terminated, full back wages and benefits, and up to $20,000 for injury to dignity or hurt feelings. So the financial penalties that can result are quite significant. So from a medicinal marijuana perspective, does your workplace have an accommodation policy or procedure? The question is not whether to accommodate, but what is the accommodation process? How is that set out in your policies? What's the role of the employer, the role of the employee, and considerations that must be taken into account, such as information that's needed from a doctor? The duty to accommodate extends to the point of undue hardship. That term is defined in the code as intolerable financial cost or disruption to business. This is a very high standard. It's going to equally apply to cannabis dependency. So again, ask whether your workplace has a policy that addresses substance abuse. I know that this is a fairly big issue in the construction world, and in terms of drafting policies, there's this sort of ongoing discussion or distinction between having policies that permit for voluntary disclosure and subsequent assistance from the employer versus having a failed drug test or having an incident that leads to a drug test and trying to require dismissal or termination. These can engage human rights issues, and they can also engage employment law to the fact that, or to the point where having a well-drafted policy can save you significant legal liability down the line. In terms of the steps for accommodation, we've sort of set out broadly speaking what those steps look like. But the tough thing about accommodation policies is there really is no one-size-fits-all approach. Each situation has to be handled on its individual and unique facts. So when you're drafting a policy, the important thing to remember is that it's the process that matters just as much as the substantive accommodation that's ultimately offered. And you also have to have a good recognition of the role that all of the parties involved play. That's the employer, the employee, and where one exists, the union. As I mentioned, while the employer has a duty to accommodate, it may not be possible to adapt all jobs to the employee's preferred outcome. Reaching the point of undue hardship is also a very individualized exercise, and there's no quick or easy answer to tell you what undue hardship will be in any one situation. But it does include intolerable financial cost. Courts will therefore look at the cost to the business to implement the accommodation. They'll look at the resulting changes to the workplace, and they will consider health and safety issues as well. For cannabis, where there is medical authorization, the issue employers face is what effect any impairment is going to have on the individual employee and the job that they perform. But ask yourself, from an accommodation process perspective, can the employee be accommodated while using cannabis by starting work at a later hour or by performing tasks seated or away from machinery? There's always going to be some options, and if you're ever facing a human rights complaint, what you need to be able to demonstrate is that you looked at all of those options and that you can provide a rational explanation for why they were not suitable. So what are the impact on policies? The reason that we have this slide in is these are the questions, these are broadly speaking the considerations that employers should be thinking about when they're looking to either draft or update their policies. Essentially, how will cannabis impact your workplace policies? We discussed briefly about zero tolerance policies may be difficult to apply in terms of extending them to the point where employees are off duty. Looking at the medical proof of need for marijuana use during work hours, having a process in place for how you'll seek additional medical information is really important. We'll come back to measuring impairment in just a minute, but it's another issue that has to be set out in your policies. We've talked about the safety of coworkers and public as well. Looking at worker privacy for a minute, this is the third issue we want to discuss, and it goes hand in hand with the human rights issue we discussed just a moment ago. So in terms of the balance that must be struck between an employer's need to maintain a safe workplace and the employee's right to privacy, we get asked all the time, how much information am I entitled to? Well, you're entitled to the prognosis, but not the diagnosis. This is the general nature of the illness or the injury, but not the actual diagnosis. The prognosis for recovery, which includes the expected duration, and any accommodations the employee may require if and when they can return to work. This is what the employer is entitled to know. We get asked quite a bit whether workers have a duty to disclose when they've been prescribed a substance. Yes, they do have this duty, but you should still put it in your policy. You should still make it clear that you expect your employees to disclose this to you. You may have 99 employees that would come and disclose this to you in any event. Your concern is the one employee that it wouldn't naturally pop into their mind to come and talk to you about this. In presenting this and in coming to groups like this, really what we're talking about is the process that is involved in instilling a culture of workplace safety. Because when you do that, when every employee knows what's expected of them and knows what to do if they have a question, knows who to talk to when they've been prescribed something, that is taking another step in fostering that culture of workplace safety that ultimately makes it safer for everybody to be at work. So let's talk for a minute about testing for impairment, what testing can and cannot tell us. Well, there is a difference between intoxication by alcohol and cannabis impairment. As mentioned, certain tests can tell if an individual has THC in their system, but it is not going to tell you if that person is impaired. Frankly, the science is just not caught up. Unlike alcohol, there is no generally accepted level of THC that signals impairment. Current testing methods only determine the presence of THC, which indicates that the individual used cannabis at some point, but cannot determine whether a person is impaired. This is the big issue between determining recent use versus current impairment. Moreover, the effects of cannabis on an average user can vary depending both on dosage and the extent to which a user is an experienced or chronic user. Some of the stuff I've read about testing for impairments is that, for an occasional user, THC can stay in the blood for up to, 7 to 10 days. But for a chronic or regular user, you can find THC in blood or urine for up to 30 days. Certainly, if you're 28 days out from use, you're not going to have any level of impairment. So what I say to employers is, ask yourself, what does a positive test actually tell you in terms of workplace safety? So this brings us to the next topic, which is drug tests in the workplace. In our view, employers should have a clearly defined policy that outlines the criteria for impairment and any testing procedures. Again, you need a roadmap, and I know that lots of employers in the construction area do have this already, but you need to be prepared for what's going to happen when you have that incident or you have the near miss, if you have reasonable cause to believe the employee is impaired. Because generally speaking, you're only permitted to test where you have reasonable cause to believe the employee was impaired while on duty, if the employee was involved in a workplace incident or a near miss, or where the employee was returning to work after treatment for substance abuse. I've had questions a few times, what about pre-employment screening? Can we do this? Generally speaking, from my view and what I tell people is where having a clean screen is a condition of entering into a contract of employment. You haven't actually made that contract. You're not in an employer-employee relationship yet, so this wouldn't necessarily impact. So in that situation, you have two parties. You have an employer and a potential employee, And the potential employee knows as a condition, if I want this job, if I actually want to, have the consideration of receiving these wages, I need to undertake this specific drug test. Well, that's a different situation than just taking somebody, an employee, off the work site. So generally speaking, you can do those pre-screening. What becomes more interesting, and questions I'm getting from the construction group and construction industry associations, is what about, subs who are bidding on a job, and it's the contractor, it's the general contractor or the prime contractor who's requiring these tests, and I know my employees aren't going to all pass. What do we do in that situation? And I don't have a good answer for you, to be really honest, I don't. I think that by and large how I've been looking at this is more from a human resources perspective than anything else. So it's not going to be applicable in every situation, but ultimately, where you have skilled trades, where you have a shortage of skilled trades, or you're looking for somebody who has a specific skill set, again, I think that there has to be this certain level of cultural shift in terms of what's actually safe versus what actually isn't. For any type of sub who's bidding on a job, I don't know. I don't work in this particular area to say, like, what the actual risks are, from a business perspective. But have the conversation. What happens? What is the real risk if you have someone with a low level of THC that you can say, look, this guy's a recreational user. As of July, as of September, this is going to be legal. We're not talking about drug tests that show, presence of cocaine or opioids or anything like that. We're talking about something that's legal. And I don't know too many employers, even in the construction area, that if there was a test that showed, if alcohol is going to stay at some low level, if you use that as an analogy, there's not too many people who would say, I'm not going to hire somebody because I know that sometimes on a Saturday night when he's watching the ball game, he drinks 2 beers. Like, who's really going to do that? So I think that we have to keep having these conversations because from a safety perspective, from a human resource management of your company perspective, there isn't any harm in having as an employee, somebody who occasionally uses recreational cannabis. What you want to be able to ensure that you're guarding against is actual impairment in the workplace. And I really do think that these are two separate things. So in terms of, just to finish up on drug tests in the workplace, there have been some attempts to implement random drug and alcohol testing by large employers. You may have read about Suncor in Alberta. It's probably the most well-known example. This is an unsettled area of law right now. We're thinking that the Supreme Court, we're sort of hoping the Supreme Court's going to hear this in the next, coming months or year or something. I would check back in. But right now, in terms of advising employers on updating policies, it's really hard to implement random drug and alcohol testing unless you have a unionized work environment and have negotiated with the union that such random testing is going to be available. So if you're an employer that may include a dangerous workplace, what do you do if there's a near miss or a substantial injury and you suspect the responsible employee was impaired? Do you have a policy or a procedure that sets out the steps you would take in that highly charged situation? Again, a primary reason to have a policy in place is to know how to react, the steps to take, and who's responsible for each of those steps in a crisis. So if testing can't necessarily determine impairment, how do we determine impairment? Well, again, I think that determining impairment starts with effective workplace policies, and these are the elements that would be included. Here, I think that the definitions are going to be a key part because impairment is not static and it's on a spectrum. So you need to know what you consider impairment from your workplace and how you're going to define that for your employees so that they know. And ultimately, this is going to come back to establishing and relying upon expectations that you place on your employees. In terms of recognizing impairment, I appreciate that everybody wants the easy answer. Everybody wants that test with that one level to show this is what's not acceptable. It's not easy, and I appreciate that your supervisors may not necessarily be trained in identifying impairment. I don't think that this is a situation where you have to send everybody to a 2-day course in Saskatoon or Edmonton or something to become some sort of, designated impairment identifiers or anything. A lot of it is going to be common sense, But again, if you have the proper policies and procedures in place, have a form, have an incident report form that has basic identifiers of impairment so that if something happens, the supervisor who's there has a tool they can use to go out and take a look. Glassy eyes, unsteady gait, right? Smells of alcohol, whatever it is. Talk to the people who were involved. And again, these are best practices. The employers who are consistently recognized as being the safest are typically those with comprehensive policies and well-trained supervisors, foremen, and employees. The idea is to instill a culture of safety at the workplace, where employees know what's expected of them and who to talk to when a safety concern is raised. So we've reviewed establishing employee expectations, and we outlined some objective criteria for how to determine impairment. The third step is how an employer will respond to an actual case of suspected impairment. The focus should always be on the employee's well-being and the safety of your workplace, but you want to have, again, the tools, the practical tools to use in the moment. One, so that you have an objective recollection of what occurred, and two, that you can rely on down the line in the event that you are facing any occupational health and safety charges, or you end up wanting to dismiss that employee and you face a wrongful dismissal action. You want to have as much evidence that's collected in the moment as possible that you can rely on down the line. Recall as well that not all situations of impairment are going to be disciplinary or culpable. You may have a situation where an employee is involved in an incident and they say to you, I have a substance abuse dependency issue. This engages human rights considerations. So it's not to say that if this happens, you can automatically fire the person, but you want to have those policies in place so you know how to respond to that type of situation. While it's important to gather information in the moment in an objective fashion, it's also equally important to remain empathetic and supportive. So in terms of employee obligations, we discussed earlier that employees have an obligation to perform their job safely, which includes the need to understand their job and the impact of using substances could have on safety. Again, establish the expectations. And we're advising employers, when they call us to talk to us about cannabis in the workplace, use this as an opportunity to have the dialogue with your employees. Talk about the dangers of workplace, or talk about the dangers of drug use in the workplace, the dangers of impairment in the workplace. Use this as an example to demonstrate the best practices, the best standard, and have a good communications plan. If you're going to use legalization of cannabis as the jumping off point to update your drug and alcohol policies, make sure you have a good communications plan and follow up regularly with your employees. Really make it easy for your employee to disclose an issue, a safety issue, or a disability. So finally, with the legalization of cannabis on the horizon, it's frankly just a good time to take a look at your safety policies, your policies on drug and alcohol in the workplace, and your workplace accommodation policies. If you don't currently have them, it's an excellent time to implement them. I'd like to thank you very much for your time. I'll certainly be around if anybody has any specific questions or wants to talk about any of the issues I've raised today. Thank you.